Well, good morning and welcome to today's webinar. I'm Beth Hawley with the Arizona Realtors, and we're proud to bring you these free webinars designed exclusively to keep you updated on issues in the industry. Today's presentation will be about 45 minutes long. If you have any questions during the webinar, please write them in the question box and we will get to them at the end of the presentation. If you'd like to change the size of the webcam video, simply click on the line separating the webcam and the PowerPoint presentation and drag. As always, today's webinar will be recorded and available next week on our website at aaronline.com. So joining us today is Patrick MacQueen, founder and partner of MacQueen and Gottlieb. Thank you. Patrick's 14-year-long legal career has been highlighted by work primarily in the areas of real estate, transactional law, and real estate litigation. He recently prevailed in several Arizona Court of Appeals matters and won with the Arizona Supreme Court. Served as local counsel in $129 million acquisition of the City North development adjacent to Desert Ridge Marketplace in North Phoenix. So welcome, Patrick, and thank you for joining us.
Thank you for having me. So I've been practicing for 14 very long years, and in that time I've seen quite an evolution of HOAs, and that's what we're going to talk about today. When I first started my career, I was at a large law firm, and we were setting up developments, we were setting up HOAs, we were drafting documents, we're sort of filling in the blanks because things were going so fast. This was 2004, 2005, during the housing boom, and so we were setting up multiple HOAs at a time. Then we sort of had this downshift in 2008, 2009, where HOAs are now collecting dues. They're going after their homeowners aggressively to collect dues. They're going after violations. So, we've seen this evolution from development to collection and litigation on that front. Now we're starting to see a different kind of pattern in the law with respect to HOAs. We're seeing a lot of coups, and when I say coup, I mean like a political coup, where we have unhappy homeowners who want to take over the board and start running the HOA themselves. I've got a situation right now where there's a reserve account of $2 million, and it's held in the Bank of China. And so it just makes you wonder why it's in the Bank of China when you couldn't find a similar bank here that might be able to help out and hold that reserve money. And then the other issue is, the big issue right now involving HOAs is with HOA foreclosures. And what we're seeing right now are HOAs that are foreclosing on their homeowners, taking over properties. And this creates somewhat of an interesting dilemma for a lot of people. A lot of people don't think that their HOA should be able to have such rights like that and be able to take over somebody's house. A lot of people are okay with the idea, so long as the HOAs are getting paid. But basically, your CC&Rs can act as a lien and allow your HOA to take over your property. This also creates an investment opportunity for those who want to buy these HOA liens and take over a property. So it's definitely an evolving situation with HOAs right now. We're going to go over some teaching points today. You can advance the slide if you would. Yeah, so I guess I want to make sure I make this clear. I'm not here for HOAs or against HOAs. I certainly think they serve their purpose. I think there's some fantastic ones out there. I live in an HOA where I pay $25 a month, and I have access to pools and green belts and parks, and I love it. And so I think HOAs are great in many circumstances. The case for HOAs, you see these photographs on your PowerPoint slide. One day, a client of ours was attempting to sell their home across the street from this, and they couldn't sell their house because the city of Peoria allowed or didn't get involved in stopping this person from putting this graffiti on their home because the person said it was, well, number one, they weren't in an HOA, and he said, hey, I'm expressing my creativity. And we disagreed, obviously, with that. But this would not have happened in an HOA. It just would not have happened. And so I'm not pro HOA, I'm not anti HOA. I just want to get you the information so that you can better serve your clients and get them the information that they need in purchasing new properties. Go ahead and advance. So the teaching points, they're here on the screen. Where did HOAs come from and why? We're going to talk about HOA documents that you'll typically see, and then I would encourage you to have your buyer clients review. I know that in many instances when you send a purchase and sale agreement to somebody, to a client, and you get it back within 2 minutes, they're certainly not reading they're not reading that purchase and sale agreement. But I would encourage you to have something in your file that suggests or strongly urges your buyer clients to read the CC&Rs, to take a look at the bylaws, to be a little bit more proactive than they are. And again, I know with some of the DocuSigns out there, these documents are coming back to you pretty quickly, and there's the likelihood that your buyer clients are actually reviewing this stuff, unfortunately, is probably pretty low. But if you have something in an email where you can hang your hat on and say, listen, I told you to read these CC&Rs back when you were purchasing this property, you're going to be in a little bit better shape, because the concern is that they turn around and say, hey, my real estate agent didn't tell me this was a possibility, or my real estate agent didn't tell me I'd be unable to paint my house in the various colors that I wanted to. So we're talking about HOA documents. I'm going to encourage you to have your clients, or put something in an email to have your clients review those documents. We're going to talk about HOA obligations, because just like licensees, board members have obligations to the association. We're going to go over some case studies, and you'll be able to see what's some of the crazy stuff that's going on out there. And then, of course, we're going to end with some tips for you as homeowners and licensees in helping clients. Go ahead and bring that forward. So you can forward one more slide. So the first real HOA is deemed to be this Levittown development in New York. It's on Long Island. And it was created by a gentleman named William Levitt. And what he did was he deed restricted 17,000 homes in New York. And the idea behind this community was that he wanted to allow a place, or have a place, where GIs coming back from the war had a place to live, and they had common amenities, and they could live near each other and support each other. And so what he was able to do was deed restrict 17,000 homes in New York. That is deemed to be the first real HOA. Now, a lot of people think the first HOA probably was Sun City or somewhere in Las Vegas or Nevada, but it was actually in New York. And then we see this trend westward of HOAs happening. Okay. Now, Levittown is deemed to be the first HOA, but I think the legal impetus to create an HOA actually came much sooner or much earlier in time. As some of you may have reviewed or seen title reports or deed restrictions from the early 1900s, there were restrictions that were upheld, that were placed in these title documents that said, hey, listen, you have to have a single-story home. You can't have chickens running around in your backyard. You can't sell to this class of people or that class of people. Some of them are these racial covenants. And so these deed restrictions sort of created the pathway for William Levitt to create the first HOA. We also have HOAs sort of gaining in popularity because of certain cultural changes. People in the 50s, 60s, and 70s wanted to move outside of the cities. They wanted to have amenities, tennis courts, green belts, basketball courts, pools, etc. And so the developers of these neighborhoods had to create a mechanism to pass along their costs. And so really that's how they did it, was through setting up an HOA. Okay, so we start seeing the development costs being passed on to homeowners in the form of HOAs, the monthly obligations being passed on to homeowners in the form of HOAs. And so now we've got a lot of HOAs. The HOAs are typically, at least in Arizona, set up in one of two ways. Okay, you either have an unincorporated association, which is largely just a group of people who band together for a common interest. Okay, so if it's me and Beth and a couple of other people who own some properties within the neighborhood, we can band together and create our own homeowners association. Or we have a situation where it's a nonprofit corporation that's set up. And those are primarily the two main ways an HOA can exist in Arizona and under Arizona law. Now, a lot of people say, well, why would you have a nonprofit versus an unincorporated association? The answer is you want to have a corporation governing the homeowners association to protect from liability. Okay, remember the law. Remember how corporations are separate and distinct from their owners, from their shareholders. And so you have a nonprofit corporation to avoid liability. So if Beth and I had our unincorporated association and somebody slips and falls in a common area, well, guess what? Beth and I now have personal liability. But guess what happens if we set this up properly as a nonprofit corporation? Personal liability would have potentially been avoided. Okay, and so when you have a nonprofit corporation, you have to treat it like a corporation. You elect officers, you elect boards, they run the day-to-day operations. And so this is something you may want to mention to your clients whenever you see an unincorporated association. Say, hey, listen, you may be buying into a little bit more risk than a typical HOA. You see unincorporated associations usually on the outskirts of town. They're not huge, but we're going to go over an example of one so that you can see the problems with unincorporated associations. So again, most are set up as nonprofit corporations. You elect officers, you have a board, you have to have meetings, etc. And so we usually recommend buying into or having a nonprofit corporation versus an unincorporated group of people. Now, HOAs can affect planned communities, condominiums. Sometimes we run into situations where there are office associations that deal with office condos. Usually, you don't see the middle finger sort of being painted on in office condos. The personal feelings aren't as great, and so you're dealing with more legal issues like, hey, who can use these parking spaces? Who's entitled to use this easement? And so the legal issues aren't as heated. You usually don't see foreclosures of HOA obligations or association obligations in condo situations, but those do exist. You also see sometimes HOAs within HOAs, and you have to mesh those documents together to figure out kind of what's going on. Go ahead and advance. So the governing documents that hopefully most of you have at least read or seen in the past, there's 4 or 5 of them for each typical nonprofit corporation that's properly set up. And the first one are the CC&Rs. And the CC&Rs are really an important document. And this is the one that is particularly important for you to suggest your clients read. Okay? The CC&Rs create design restrictions. They state the purpose for the HOA. They have restrictions on animals. They have restrictions on rentals, and we'll talk about that a little bit more. But the CC&Rs are incredibly important. The CC&Rs also provide rights in favor of the HOA to impose fees, fines, liens, etc. And so again, it's a very, very important document. Let's think about this. Your HOA, your CC&Rs can act as a lien on your property. Okay, so it's almost like another security interest. So you have a mortgage in favor of Wells Fargo or Chase Bank as a primary lender, and you've got an HOA obligation, which is essentially a secured obligation, and they can foreclose if you stop paying them. So think about that opportunity for an investor client of yours or investors in general. They go and buy that HOA lien, can take over a property, and all they have to do now is pay off your first mortgage loan with Chase or Wells Fargo for 90 cents on the dollar, and now they own your home. And so that's a pretty interesting proposition that exists right now. So that's one of the big issues we see with CC&Rs, is that people are foreclosing. Another issue we've seen is an HOA that restricted the rights of homeowners to own guns. And that wasn't real popular. I don't think that would be real popular in Arizona, but it's upheld. The CC&Rs are a private contract between you and the HOA and you and your neighbors. If you guys all contractually agree to restrict your rights to have and possess guns, it's going to be upheld. The Second Amendment, everybody says, well, wait a minute, what about the Second Amendment? The Second Amendment only applies to the government trying to restrict your right to carry and possess weapons. So you can privately agree through your HOA to say nobody's allowed to have guns. Again, doesn't happen much here in Arizona, but I've seen it happen. So again, these CCNRs are very, very popular, or very, very powerful. Remember, it's a contract between you and your neighbors, and you and the HOA. And so if there's a violation by one of your neighbors, you can sue your neighbor for breach of contract for breaching those CCNRs. It's also a property right. So it's just so powerful, and that's why we always encourage people, you got to read these things. You have to. The CCNRs also usually address a rental situation. If you want to rent your property, you may have to comply with certain obligations imposed by the CCNRs. And what we're seeing now are restrictions being placed on the VRBO, Airbnb rentals. And so if you represent a buyer who wants to come in and restrict, or you represent a buyer who wants to come in and do an Airbnb as an investment, or do a VRBO type of home as an investment, well, you got to make sure that the CCNRs don't restrict day-to-day rentals or weekly rentals or monthly rentals. And what a lot of HOAs right now are doing, particularly in some of the resort areas of Scottsdale, Sedona, Flagstaff, they're actually restricting the ability for you to rent these on a day-to-day basis. Now, I don't know how well they're able to stop that, but it's certainly happening, and HOAs are trying to put a stop to some of it in certain areas. So you need to make sure that your clients are aware of that if they're purchasing a home to list on VRBO or Airbnb. Okay. So the CCNR is a very powerful document. I encourage you to tell your clients to read those. The bylaws are also important. Remember, this is a corporation. This is a nonprofit corporation, so we have to have bylaws. Bylaws basically deal with governing the corporation itself, when the meetings are going to happen, who can be elected, how the elections occur. So those are important as well. Articles create the HOA. Articles create a corporation. And then sometimes we have rules and regulations which also address certain things you can or can't do. So that's another thing that you're going to want to encourage your buyers to review. If it's important that they can have parties on their patios, but there's a restriction on having barbecues, which sometimes there is, well, then that may be a place that your buyer clients don't want to go to. Now, under the PowerPoint slide, it says typical bylaw violations. The typical bylaw violations occur in voting situations. You'll sometimes hear of situations where existing board members hear that there's some dissatisfaction with what they're doing. And so what they'll do is they'll try to postpone a vote, or they'll send out an email saying, hey, the vote's not going to occur until June. Well, under the bylaws, the vote has to occur every April. And so they send out this email hoping to discourage people from voting, and by telling them it's going to be a vote at a different date, and that's not allowed, and that's a violation of the bylaws. Go ahead and advance. Now, for those of you who are on a board for your HOA, I would encourage you to get off immediately. No, I'm totally kidding. I just want to remind you that you do have fiduciary obligations to the homeowners and to the association. The first is a duty of care. The duty of care is difficult to articulate. It sort of gives attorneys a lot of wiggle room to argue that the duty of care was violated or it was not violated. The duty of care basically says, in connection with your obligation as a board member, you must be diligent and careful in performing your duties. What does that really mean? I don't know. That's a tough one. And so again, it gives a lot of wiggle room to say that you were in compliance with your duty of care or you weren't. And so that one's difficult to articulate. The second duty that a board member has is a duty of loyalty. The duty of loyalty means that as a board member, you must act in the best interest of the HOA. You can't engage in self-dealing. And what that means is, if you've got a brother or a sister who own a landscaping company and you want to use their landscaping company, you better get some other quotes from other landscaping companies, because you may be violating your duty of loyalty if you're not finding the best deal out there. Okay? Or if you personally own a landscaping company or a painting company, you got to make sure that the board is informed that there may be a conflict here and that you own an interest in the painting company or the landscaping company. Otherwise, you may be in violation of your loyalty obligations to the board. Okay, there's also a record-keeping obligation. The board has to keep records. Now, there is a notable exception to the duty of loyalty, and it's called the business judgment rule. And this is somewhat of a corporate concept, and a lot of HOA rules come from corporate law. The business judgment rule basically says, listen, if you can come up with a good reason to use your brother's painting company or to use your own landscaping company because they're 50% cheaper and they do better work, well, you don't violate that duty of loyalty because you have a sound business reason for doing what you're doing. Go ahead and now, I want to get into some fun case studies. And these are real life case studies, and I'm curious to hear what you guys would do in these situations. And I'm curious to hear what you guys say about these, so feel free to ask as many questions as you need to on these. But these are real life situations, and they can get these HOA situations can get quite frustrating, and you'll see why. So, first example is Mind Her Own Business Mary. So Mind Her Own Business Mary has owned a home in the Ahwatukee area for 15 years. In her backyard, she has a large eucalyptus tree. Her neighbor across the backyard became president of her HOA. There's nothing in the governing documents or CC&Rs addressing plants in homeowners' backyards. Several months ago, Mary received a notice from her HOA that she needed to trim her tree. Mary complied. She then received another notice that she trim her tree and a fine. She trimmed her tree and paid the fine. She then received another notice and another fine stating that she did not properly pick up the leaves when she trimmed the tree, and she was warned that her tree trimming was inadequate and failure to remedy would result in the HOA entering her yard to trim the tree. She asked that the HOA give her guidance on what was expected, and the board indicated that they wanted to see a properly trimmed tree. True story, Mary was extremely frustrated. She felt that she did everything proper. So what are her options? Well, unfortunately, she had to hire a law firm. And ultimately, the court said, no, this is ridiculous. This HOA is acting in a discriminatory fashion. She did everything possible. She was awarded her attorney's fees. She had to file what's called a request for declaratory relief, where you get a court order saying, hey, HOA, you're acting improperly. During the course of this case, we found out that the neighbor behind her, who was now the president of the HOA, owned several landscaping companies. And so it became very obvious that he was pushing for business as opposed to actually really caring about her eucalyptus tree. Now, I've heard other people, when I teach this class, I teach a 3-hour class on this, everybody says, well, eucalyptus trees are problematic. And that's not really the point of this anecdote, but or the example, but whether they're aggressive trees or not, the issue here was she had done everything. The HOA was acting in a discriminatory fashion. They were targeting her, and it turns out there was a reason why they were targeting her, and they wanted more business for this new president. Now, another one. This one will surprise you guys as well. This one's called Donna the Dog Lover. Donna the Dog Lover lives in a Mesa neighborhood subject to CC&Rs. The CC&Rs do not restrict the ownership of household animals, just horses and other livestock. Donna loves to walk her dogs in the neighborhood, but is not great about picking up after them. Several residents complained to the HOA about Donna's dog's use of the neighborhood as their restroom, and Donna was fined $1,000. When Donna refused to pay the violation, the board voted to ban Donna from all common areas, including tennis courts, pools, and parks. Okay, so this one usually splits the class between those who are angry with Donna and those who are angry with the board. In this particular situation, Donna said, listen, you can fine me all you want. You can require that I pick up after my dog, but you can't ban me from the common areas. I have the right to use these common areas. You can ban the dog from the common areas as well, but you cannot ban me from the common areas because of fines. Now, if she wasn't paying her monthly dues, she could be banned from the common areas. But because this was a fine issue, she could not be banned from the common areas. So she too had to seek declaratory relief, got her attorney's fees back, and is still continuing in the obnoxious behavior that she previously engaged in. But the point there is that you can't ban somebody from common areas if there's just a normal violation. The other point of that is interesting. What a lot of HOAs are doing now is they're DNA testing dogs. And people, when I mention this, they go, what? So a lot of times in communities, particularly those in high-rise buildings, if you want to have a dog, you have to submit your dog to DNA testing. And then if they go and find a mess that your dog has left, they have the DNA, they'll send it out, they'll charge you, and they'll figure out whose dog left the mess. So something out there to tell your buyers who may be interested in purchasing in one of those types of communities. Now, you go ahead and advance. Oh, the snowbirds one. Let's do the snowbirds one. Okay. The bylaws of ABC HOA require that the election for new board members occur every March. Most of the owners within ABC HOA are snowbirds and leave the state in late April or early May of every year. The existing board heard rumblings of dissatisfaction from the owners in ABC and sent out a notice that the election of board members was going to be in June of this year. What can the dissatisfied owners do? So this gets into that bylaw situation in voting that I mentioned a little bit earlier. You cannot change the date of a vote that's provided in the bylaws. Okay, so that's a clear violation. Now, I almost learned a very important lesson in this particular situation. If you want to stop an election because you believe that an election is going to be improper, you've got to make sure you do it before the vote occurs. Okay, and the reason you want to do that is based on election law. There's election law in Arizona, but you need to do that because the courts are otherwise going to say, well, you're trying to call into question this vote. It's because you lost and you have sour grapes, as opposed to there being a real reason. Okay, so you have to stop an illegal vote before it occurs. So that's the lesson of that particular anecdote. Go ahead and advance. Now, this one was a fun one, and it requires some listening, I suppose. We represented Nate in this particular situation, or we represent Nate in this particular situation. And this happened Super Bowl Sunday last year, not this most recent Super Bowl Sunday. But I'm going to read this, and it'll make more sense. That drawing will make a little bit more sense. New build Nate purchased vacant land, subject to a brief set of CC&Rs that required the construction of single-family homes of at least 3,400 square feet, and required the vote of 75% of the owners to change the CC&Rs. The HOA consisted of 4 members, including Nate, and 3 of the 4 members already built their homes. 2 of the homes faced a north-south direction, and the adjacent property faced east-west. When the owner with an east-west home learned that Nate wanted to position his home in a north-south direction, a vote to amend the CC&Rs took place, and the existing owners elected to change the CC&Rs to require that, quote, new homes were required to face east-west. This change only affected Nate because all other homes have been constructed. Okay, so you see Nate in the upper left-hand corner, and this is up in Cave Creek, Carefree area. So Nate has the property. It's a large acre parcel, and it was raw land at the time he bought it. He goes in there. 3 of the 4 homes in this particular development were already built, and there were CC&Rs that were recorded. And in those CC&Rs, it says nothing about the manner in which the orientation of the homes would be. So Nate, seeing that, the homes below him and to the southeast of him were in a north-south direction, he wanted to go north-south as well. So he gets these plans, he creates drawings or has them created, spends $140,000 to orient his home in a north-south direction. Well, the day before he's going to dig and build this home, begin building a home, the guy with the east-west property says, hold on a second, I want the 2 northern homes to go in an east-west direction. And Nate, I don't care that you've gone in a north-south direction or want to go in a north-south direction. The CC&Rs allow a 75% vote to amend them, and I'm going to seek to amend them before you dig ground. And so the existing homeowners all had a vote on Super Bowl Sunday to require that all new homes go east-west. And so obviously this change only affected Nate. So Nate's stuck here in this association with these folks that want him to go east-west after he had already spent a boatload of money, $140,000, to orient his home in a north-south direction. And so he says, well, what can I do? So the vote occurs on Super Bowl Sunday. in one of the guy's garages. And this is what happened in an unincorporated association. And so every single other homeowner in that 4 homeowner subdivision there was named in a lawsuit. And now that you know about this lawsuit, you won't be called as jurors because you know one of the attorneys handling the case. So in addition to teaching you a lesson about unincorporated associations, I've also gotten you out of jury duty. But in any event, we don't know how this is going to turn out. Nate went in there thinking that there would be no problem going north-south, but he knew as well that a vote could occur, a vote could affect the way his property was oriented. Our biggest argument, I think, is that the construction process had begun prior to the vote occurring. Our argument is that the construction process started when he began pulling permits, and therefore the vote is rather irrelevant because the vote happened after he started construction. The vote, remember, only affected new construction. So we'll see how that one turns out. It's a tough situation. Obviously, a settlement would be in probably Nate's best interest, because I don't know that he would want to live too close to these other folks here who are going around and amending CC&Rs on the eve of digging ground. So anyway, hopefully you won't get called on jury duty for that one. And we have one more, and this one's a fun one as well, dealing with election law again. Board member Betty was a member of our HOA's North Scottsdale board for many years. One of the other board members, Painter Pete, did not like Betty because she voted no to using Painter Pete's company to paint several of the community parks. About a month prior to the upcoming election, Painter Pete sent out flyers to owners showing what the ballot would look like. However, the ballots submitted by Painter Pete were not the actual ballots, and Painter Pete crossed through the name of board member Betty and included a write-in vote for one of Pete's neighbors, giving the impression that board member Betty was no longer running for a board position, even though she was running for a board position. The election occurred, Painter Pete was reelected, as was the write-in candidate. Board member Betty was informed that she received one vote, her own. She was unaware of the ballot issue until after the election. So Painter Pete and board member Betty were members of their association for several years. Betty and Pete didn't see eye to eye on everything. Pete wanted to use his company to paint all of the HOA's parks. Betty said no. So what Painter Pete did is he took an election ballot, modified it, and circulated it to neighbors and gave the impression that Betty was no longer running for a board position, even though she was. The result, the election occurs, Betty gets one vote, and it was her only one. She then finds out after the election occurred that Painter Pete was canvassing the neighborhood and letting everybody know that she wasn't running, which is untrue. And we find these ballots that he had sent out. So he was sued for defamation, and you would not believe how many defamation claims we see in dealing with HOAs. It's almost like high school, and it gets pretty personal. And this was one of those examples. Ultimately, Betty prevailed. She was awarded $70,000 for her defamation-based damages, which was fairly significant. The issue, though, is that Painter Pete had insurance to cover this situation. HOAs have insurance for these claims. Anytime you sue an HOA, you're essentially suing yourself, so your premiums go up. So it's somewhat of a frustrating situation. But ultimately, Betty prevailed. She said, I don't want to run for the board position anymore. Painter Pete also agreed to not run anymore. But this is the type of stuff that we're seeing this day and age in HOA situations. So let's go over some tips for you as licensees helping your clients purchase within HOAs. Okay, this first set of tips is for you as homeowners, and it really applies to everybody, not just you, your clients, but tips for homeowners. Number one, regularly inspect HOA books and records. So a lot of people don't realize this, but if you go to your board and ask for the books and records and meeting notes and those sorts of things, you're allowed to collect that information. Within 10 days, your board has to provide that to you. Okay? Otherwise, they're violating Arizona law. This is where a lot of lawsuits against HOAs begin. Somebody wants to start looking into why certain votes are happening, why certain things are happening within the HOA. They go in, do a records request, get those documents, and start combing through them and seeing violations of Arizona statutes or Arizona law. Okay, so regularly inspecting your books, will allow you to kind of understand what's going on. Pay your assessments. That's an easy one. Read your CC&Rs, bylaws, and other governing documents before purchasing or making changes to your home. Again, I understand the impetus and what people are doing these days is they're not reading the documents, and then they run into a situation where they make changes to their home. They put up a pergola in their backyard, and then it's a situation where they're having to ask for forgiveness or having to tear down buildings and reconstruct things at quite a significant cost. So read those documents. If it's important that you be able to have a pergola, or if it's important that you be able to make certain color changes to your home, make sure you're buying into a place, first of all, that allows for those sorts of things. Number 4, request a hearing for alleged violations. You are allowed to express your position at a hearing, and the board has to listen to you. And then, of course, attend board meetings and ask questions. I've attended a number of HOA meetings, usually because I'm representing somebody in connection with an HOA matter, and there's hardly anybody at these meetings. And so I would certainly encourage you to attend board meetings and ask questions. Go ahead with the next slide. So this should say at the top of your slide, HOA tips for licensees. Okay, so these are your tips for licensees in dealing with homeowners associations or buying and selling within an HOA. Okay, number 1, we talked about this. Tell your buyers to read the CC&Rs. Please do that. Put something in an email. I don't care if they read them or not. I want you to be protected. I don't want them coming back on you saying you never told me to read the CC&Rs. Throw something in an email. Tell them to read the CC&Rs. Tell them to read the rules and regulations. We went over this example. If it's important that you have barbecues regularly, but you're in an area where there's wood, trees and woods and wood decking, and the HOA says we're not going to allow for you to have barbecues on barbecue sets on patios, well, then maybe that's not the place to go for your buyer. Tell your buyers to inquire into the health of an HOA. What happens in certain situations is you buy into a place and a haboob comes in and wipes out the tennis courts. Well, now, instead of having money in a reserve, the HOA has to go to all the board members and say, hey, guess what, we're going to have this assessment, and now you have to pay a bunch of extra money so we can fix these tennis courts. So had the person looked into the health of the HOA, they would have realized there is money in a reserve, there isn't money in a reserve. So it's something to consider as a buyer. Put something in an email, throw it in there, hang your hat on it later if they ever come back and say, well, you didn't tell me to do this. 4, require that CC&R violations be addressed prior to close of escrow. If you know that there's a violation, make sure it's cured prior to close of escrow. Try to get the HOA to sign off on that before you allow your client to close escrow. Because guess what? Your buyer clients are going to inherit that problem. I've seen it happen many, many times. And then, of course, always use the HOA addendum. That's all I've got.
Okay, great. Do we have any questions? We've been kind of hot. Mm-hmm. Sometimes it takes a while to come in. All right. So we have, they live in a community that is still under control of the builder management for enforcement of the CC&Rs. The current management has been selective for the last 4 years on which ones they enforce, which CC&Rs they enforce. They started in the last year enforcing those that they can view during the hours of 8 to 5 when the management company is working, but they refuse to enforce those such as parking on the streets after 10. As they state, they don't work those hours, so they therefore cannot enforce, and either the community must walk around after 10 p.m. and send in pictures, or wait until the builder turns over the HOA.
Yeah, that's a very frustrating situation. The selective enforcement, it happens a lot. We run into situations where somebody will xeriscape their front yard and the next door neighbor wants to go and xeriscape their front yard, and they go and do almost the exact same thing as the next door neighbor, and then they get the violation. And so the selective enforcement is an incredibly frustrating situation. And the advice usually is, hey, you got to wait until the declarant, the developer here, turns it over, and you can have a board that you guys can go and hire your own property manager and deal with it that way. Alternatively, you may have to get involved and take your own pictures and push the issue yourself. Now, if your neighbors are violating the CC&Rs, which it sounds like they may be, you also have a private right of action to go after those neighbors and to try to get that to stop. Remember what I said, the CC&Rs create a contract between you and your neighbors, and so if they're violating a specific provision of the CC&Rs or the rules and regulations, then you may have to take matters into your own hands by sending a letter saying, hey, we're going to do this if you don't stop doing this. So that's part of the problem. The selective enforcement stuff is incredibly ugly because, like I said, it happens a lot. There's also a waiver provision or a provision in most CC&Rs that basically absolves the board from any liability for selective enforcement, or that's what boards try to argue, is that, hey, look, just because it's a waiver provision, just because we enforced it one time doesn't mean we're going to enforce it again, or just because we're enforcing it now doesn't mean we're going to enforce it with respect to your neighbors. And so the HOA boards have put that into most of the CC&Rs and use that as wiggle room to get out of this selective enforcement issue. So I would encourage you to take your own pictures, send them to the board. It may be a breach of fiduciary obligations if they're enforcing it in certain situations and not in others. I take the pictures, document what's going on, and then hopefully this thing will transfer to a normal board as opposed to the developer or declarant pretty soon.
And they'll have lots of fun with that, won't they? The new board.
Exactly.
So say you have a neighbor with a tree that has grown over the fence in your pool, and it's always dropping leaves in your pool, and the CC&R doesn't cover that. What do you do?
So if that sounds like a nuisance situation, so the CC&Rs could cover that. So most CC&Rs will say, listen, you can't do something on your property that creates a nuisance. And to me, that could be a nuisance. It's also considered trespass. So if you allow anything to come over a wall to your neighbor's home, you remember that you're entitled to your home, the land, and the space that goes directly above it. And so they're creating a trespass situation. They may also be negligent as well. So there are certain things that you can do. I hate to tell people just go and chop it off. Frankly, the law probably allows you to do that, but I don't want you to kill a tree because then your neighbor may have a claim against you. So you need to be very careful with that. Approach the neighbor, say, hey, listen, can you get this thing to be trimmed back? But from a legal standpoint, that tree and your neighbor is causing trespass. They're trespassing on your property. It may be a nuisance and it may be negligence. And so there are certain things you can do. Cutting the tree is probably the second step that I would take. I would certainly try to talk to the neighbor first. But you're right. But that could be a violation of CC&Rs, even though it doesn't specifically say anything about that.
So what happens if there is something wrong with, or something needs to be fixed with something that the CC&Rs do cover, but there's no reserve, and it's necessary, like a structural flaw? Yeah. You can't let this go.
Yep.
What do you do?
Happens all the time, and you're going to have to pay. So the board will create a special assessment, and all of the homeowners have to chip in. So you usually see these in condominiums or townhomes, and the board will have to create an assessment, and all the members or all the other owners will have to pay that as well to cover that structural issue. That one happens quite a bit. Roofing issues, structural issues, those sorts of things. And so a lot of times we see boards or HOAs trying to get out of that because they don't want to have to deal with telling the members or telling the other owners, hey, we have to create this special assessment, because a lot of times they're members as well. And so they don't want to have to pay it as well. But So we see a lot of times boards will try to say, well, this is probably a homeowner issue, even though it's not. And so sometimes homeowners will have to take matters into their own hands again, pay the contractor to fix the issue, and then submit the invoices to the HOA. First step, though, is try to get the HOA to handle it. And if they don't, and you're continuing to get water into your house, or there's a structural issue that's not safe, well, then you got to fix it yourself, and seek reimbursement from the board.
So is a question that's very similar to my own experience.
Yeah.
I just bought a house in an HOA, and I purchased it at the end of last year. But I got a notice very soon after that they were considering raising the monthly fee.
Mm-hmm.
So for someone who is aware of that before they buy,
Yeah.
how do you find out how much that fee is going to increase?
So definitely contact the property management company or somebody associated with the HOA prior to purchasing. A lot of times HOAs will mail things out to tell homeowners that this is coming. You may be getting into a disclosure issue as well, because if the prior owner of the home knew this, didn't say anything, then you may have a disclosure issue from that seller, particularly if they're trying to slide that under and not tell anybody. So that one happens a lot too. People try to get out of HOAs that are going to be raising their dues, and they don't tell people. So it's very important that you call and ask about the financial health. Try to get that information prior to closing, because if that's something that's material to you, that's important enough to you, you got to check into it prior to closing escrow. But it happens a lot.
That's too bad.
Yeah.
Not surprising, but too
Yeah.
bad. So with anything, I'm assuming that you first try and work it out with the HOA directly.
Yeah. Yeah. I think that's important to try. A lot of times, it's the boards have their own agendas. The boards have their own unique personalities, and so obviously, and so same with neighbors. You try to work those things out if you can, and then you seek legal advice if you have to.
Okay. Well, I think that's it for the questions. Do you have any closing thoughts?
No, that's it. I appreciate everybody's time, and I'm curious to see where these trends go from here. I think that the foreclosures is going to continue to be a big issue, as well as the VRBO Airbnb situation, and how private CC&Rs can address those situations, but municipalities really can't do much. So I think those are going to be the two trends.
Great. Well, thank you, Patrick, for joining us today, and thank you all for joining us as well. Our next webinar will be the power of engaging drip campaigns, how to close more of your expensive and time-consuming leads, and that will occur on March 5th. Also, registration for our annual 2019 Arizona Realtor Convention, March 25th to the 28th, is now open. So please take advantage of that. It is going to be awesome. Great business building opportunity. Go to aaronline.com for details, and have a great day.